I don't see the difference in doing this with your thumbs while you're looking down, looking at your phone, why you can't get a conviction for somebody for that in any court in this state. But maybe I'm off. Okay.
Delegate Albo. Okay, so I'm gonna make a motion. Motion is to pass by for the day, but I don't want it to be thought of as a motion trying to kill the bill. It's a motion to try to keep it alive. I am never, ever, ever voting to lower the punishment for texting to a traffic infraction, because I think texting, like Delegate Gilbert said, is already reckless. I also don't like the concept of putting more words in the statute, because all it does is it creates more loopholes for Dave Albos and Todd Gilberts and lawyers to get people off, because the more qualifiers you have, the more defenses you create. The idea that I would have is the one we've been dancing around for a while, is you take the reckless driving statute and you make it clear that manipulating a handheld electronic device is in fact behavior that can be considered to endanger life, limb, and property. That will give the bill a fiscal impact, but it's only going to be $50,000, and I found out from Chris today that we have some money to play with, and this would certainly, if we could find a bill that we like, would certainly, I think, meet our threshold of sending it upstairs. So that my motion is to pass by for the day.
All right, now, let me ask you this. So you said there's a Minshew bill. Right. Okay. So what I'd like to do is going to appoint you to this head of the special subcommittee. No, Gilbert's getting on it too. And Charnel, you can appoint one of your colleagues to the special sub since they're not here. Pick one. Mullins it was. All right, so. So everybody, let me just remind everyone so that the time is short, and that we have 2 more meetings of this subcommittee. We've got Monday and Wednesday, and both days are already full. So what I would suggest would be, that's actually a pretty good cross-section. If Gilbert and Albo and Mullins like it, you're probably pretty high cotton. If you don't, this is, I mean, we're just chasing our tails again. We've been doing this for years, and we keep ending up with the same difficult issues, and we end up in the same different subcommittee. So let's do that. So we will go by for the day. Let me ask the staff.
Let's try to get everybody together tomorrow sometime. I mean,
All right, so Delegate Albo is the chair of the special sub. Do you have a time, Delegate Albo, and a place?
I would have to ask people to run my life, which is my secretary.
right after the agenda.
Yeah, that's a good idea.
Okay, so at the conclusion of the General Laws Committee, in the Delegate Albo, this is like Mad Libs, you can put in a place.
Well, at conclusion of general law, we can do
Another meeting,
such a meeting. Okay.
All right, so the special sub will meet in the blank, which is Albo's office, to discuss a draft bill. Very good. Okay. Let me ask staff, could you inform Minshew, since if we need to do another bill, this should be in the same wheelhouse.
We need a Commonwealth attorney there. We need the police there.
All right, so Becca, you need somebody to just pick somebody to be the designated person for this. Okay.
Not Doucette.
I'm going to actually come up with something.
This works.
Okay. And then staff, at least one of the 3 of you have got to be there to help. Okay.
Is there anybody who's representing like handheld wireless device people? Anybody here? Fred, are you representing one of them? Car manufacturer? Yeah, I mean, I guess one car manufacturer and one Verizon or AT&T.
You understand the application laws play out in this life. So I'm happy to bring them in.
After?
Yeah.
Okay, we'll come up with a draft and then we'll have to figure a way to get it around to the industry. Okay.
All right. All right, so Delegate Anderson, you understand the marching orders?
Yes, I do.
All right.
And we commence tomorrow after general laws.
Okay. All right, so that takes off the docket Delegate Anderson's bill. Now, we have to get to the hard parts of our docket.
Mr. Chair.
Yes. All right, so we have about 10 bills that deal with the issue of driving and losing your license. We have discussed this some amongst ourselves. Delegate Lupasi had an early interest in this issue last year, so his bill will probably be the primary bill that goes forward, and there's 4 or 5 issues that are not incorporating his ideas, even in his bill, we're happy to take ideas from other bills. And what I would suggest we do is we can start going through the bills when we just sort of talk about what the idea is. So, unless I know what your idea is, but other people may not. Once all of the ideas are before us, we'll take public comment, or else we'll end up just repeating the public comment for every person that comes before us. And then we can start to slice and dice the bills and kind of come up with what's going to be the product of the committee. I've got some ideas on how to organize all this, but it seems like a sensible way to proceed. It'll make sure we don't make every page we say until midnight. Does that track? Does that make sense for everyone? Okay.
Maybe take all the public.
That's what I'm saying. Yeah, that's what I'm saying. So then they don't have to be repeated after every bill, because many of the bills will be addressing the same general topic. All right, so let's look for patrons who are not in the committee. I just summoned Lou Posse, and I saw Dave in the back, so we'll do him first. And we have Lou Posse and Leftwich. I will summons them, and then several of the rest of us are either on the committee or we're going to have staff present the ideas. So, David, why don't you go ahead and Delegate Rock, go ahead and present your ideas, and then you're welcome to stay for the next couple hours while we work through it, but you don't have to if you don't wish to.
I appreciate that, Mr. Chairman. Mr. Chairman, the idea that I would like to put forward would be to go big with House Bill 2048, which proposes to repeal 46.2-395. As you know, Virginia Code 46.2-395 imposes automatic and mandatory driver's license suspension for failure to pay court costs, fines, and results in hundreds of thousands of people having their license in a suspended status every year for failing to pay court debt regardless of why they didn't pay. We can nibble around the edges of this, or we can fix this. Repeal would be the simplest and best solution. Driver's license suspension should be reserved for dealing with true threats to traffic safety, not for being unable to pay court costs and fines. It will save law enforcement time and resources spent on enforcing suspensions, including time spent on traffic stops, court appearances, as well as dollars spent on incarceration. It avoids costly procedures, notices, and hearings that must be provided before the state suspends a license. This would put over 647,000 people suspended only for costs and fines back on the road, and lifts the indefinite failure to pay suspension for an additional 330,000 people who are suspended for other reasons. Repeal of 46.2-395 does not relieve offenders from the obligation to pay court costs and fines. Repeal would leave in place numerous other law enforcement mechanisms, including tax intercept, wage garnish, and a judgment docket against the defendant that attaches to real estate and appears on credit reports.
I think what the chairman wants you to do is to tell us the mechanism. I think all of us are agreeing that probably the problem needs to be solved. What is the mechanism that you use?
He was going through it. He said that they will just not, they'll repeal it. They will not take a license for not paying fines.
So your thing is just totally repeal.
Yep.
That's correct.
Okay.
My closing remarks.
Please, no, go. Yeah, that's fine.
I would like you to consider that that people who can pay walk out of a courtroom and over to the clerk and pay because they need their license. Licenses are not necessary to function. If you assume that hundreds or perhaps even thousands of people can pay but choose not to as an act of defiance, the automatic revocation makes perfect sense. I think it's far more plausible that many who don't pay because they cannot. Automatic revocation is a punishment which hurts individuals, families, law enforcement, courts, and has a vast cost to taxpayers. It also takes hundreds of thousands of people out of the workforce, so I hope you'll act favorably on the bill. Thank you.
Delegate Rock, thank you. Okay, and I saw Delegate Lopez. What we're doing is we have about 10 bills. We're just going to have everybody present their idea, and then we'll take public comment, and then we'll start the slicing and dicing and putting it together. So you're welcome to stay for all of that. But if you want to just sort of give us what is the idea of your bill, and if we like it, we will go forward with your bill, and if not, it'll be considered as part of the other bills.
And so I hope you won't take this as any kind of slight, but I have 4 bills at the same time, but I will definitely come back and, try to be part of the process of this.
You are not slighted. Please, tell us what is in House Bill 1862.
1862, dealing with the suspension of driver's licenses. Basically in Virginia, there are currently 647,517 individuals suspended only for non-payment of court fines and costs. By comparison, there are 200,251 persons suspended for other non-driving related convictions. Many Virginia residents only rely upon their driver's license to get to work and complete other necessary daily tasks. When a person's driver's license is suspended, they may face a difficult dilemma. Obey the suspension and potentially lose their ability to provide for their families, or drive anyway and face further punishment, even imprisonment, for driving while suspended. In addition, arresting and prosecuting individuals who are driving on a suspended license takes additional time and resources. A study done by the American Association of Motor Vehicle Administrators in 2013 noted that it took 9 hours to arrest and prosecute an individual arrested for driving while suspended in one county in Ohio, with 7 of those hours being spent by law enforcement. As the number of people suspended for non-driving related reasons increases, it is reasonable to expect there will also be an increase in the number of persons driving while suspended who must be processed through the criminal justice system. This taxes the resources of the criminal justice system, especially for law enforcement. This bill requires courts, prior to suspending a driver's license for non-payment of court fines and costs, to hold a hearing to inquire into the reasons for the non-payment. It further provides that the court may suspend the license upon finding that non-payment is due to an intentional refusal to obey the sentence of the court or failure to make a good faith effort to obtain the funds for payment. If non-payment is due to any other reason, the license shall not be suspended, but the court may take a number of actions meant to assist the defendant to meet his obligations to the court. By requiring a hearing prior to suspension and limiting suspension to those who are flouting the court's authority, this bill will assist those people who wish to meet their obligations but find it difficult to do so because of limited resources. Let's not hurt people because they're poor and make it harder for them to live. This bill draws on the standard used by 19.2358 to provide a framework for courts to distinguish between those defendants who are flouting the court's authority and those who require assistance to meeting their obligations. By requiring a hearing prior to suspension and limiting suspension of those who are flouting the court's authority, this bill will assist those customers who wish to meet their obligations but find it difficult to do so. I think it's a bill based on fundamental fairness, and right now we've got a slightly broken system, and I hope that the chair will help us get through this.
All right, so someone gets a reckless driving ticket, $100 fine, which is a very common charge. At the end of the case, the judge says that's a $100 fine, 61 in court costs, 161, and the usual thing they then say is you got 30 days to pay.
Right.
In my jurisdiction, they say, can you successfully pay within 30 days? One of the issues is not every court does it that way.
Right.
30 days go by, the payment's not in. Your bill would...
Suspend the license.
Well, that's certainly the current law. What happens under yours?
You would have a, the bill would require the courts, prior to suspending the license,
Wait.
to hold a hearing.
You. I'm sorry, just the pronoun you said you, the court or the defendant?
The court
Okay.
would have to hold a hearing to inquire into the reasons for non-payment. And then after they determined that it was basically, there were good reasons or bad reasons, that if it's for, like I said, if non-payment is due to an intentional refusal or flouting the court's authority, and they have not made a good faith effort to time out.
Sorry, I'm sorry, I'm just trying to go through. The 30 days go by, we're on the 31st day. Is the defendant ordered to come back in, or do they do a show cause and track him down, or how do they get him back in front of the court?
I believe they would be asked to come back to have a hearing about whether or not they could, through what mechanism.
That's what I'm saying. At the time that they don't pay, are they ordered to come back if they haven't paid within 30 days?
Right, before they can actually issue the suspension of the license. I mean, before they take that action as the court, they would have a hearing.
Okay, I'm not actually, you have a big picture thing, I'm actually very small. This guy walks out the door with a fine, he has 30 days to pay before there's any issue. 35th day arises, he has not paid. How does he then reappear before the judge for this hearing?
I'd actually have to I'd specifically ask the clerk of the council. They can say what the current process is.
Well, current would be then they have to get the deputies to go find him and serve him with a show cause, and then he would be show cause, given a date certain to come back, and that would be the date he'd come back, but they'd have to deliver that somehow to him. And since it's criminal, it would have to be in person. Okay.
Mr. Chairman, it's through a show cause mechanism that
Okay.
this
All right.
requires.
All right, sorry, go ahead.
I completed my testimony.
Very good, okay. Anybody have any questions for Delegate Lopez?
I have a question for
Delegate Gilbert?
Supreme Court. I'm sorry, I know you don't know this off the top of your head, but can you, or could you find out what percentage of defendants who owe fines and costs don't pay in a timely fashion and get suspended, or can you tell us what, or even a raw number of how many people that represents annually?
I believe we forwarded Delegate Bell
All sorts of good data, I'll try to find it.
statistics, maybe. I have the email someplace and I can,
Just trying to figure out how many more deputies are gonna issue show, or serve show causes, and how many more court hearings are gonna be held, and how much more court time is gonna be taken up.
All right. Thank you. Yes, ma'am.
I believe DMV may have some data. Our records are by charges, not individuals, and some of them have multiple
Gotcha.
charges. So they may be able to help.
Do it by charges, I mean, we'll just cut it in half, or, I mean,
Mr. Chairman, last year, 346,000 people were suspended and 61,220 paid.
What are the numbers again?
346,000 were suspended and payment was received by 61,220.
I'm sorry, the 61,000 out of the 340 paid?
Yes, sir.
I think, do you know how many just paid? How many normal people went through the system
We
and paid?
would, that would be a question for the Supreme Court because we only know when they have not paid because then they tell us to suspend. So we don't know how many people paid before the 30 days.
So only 285,000 hearings that we're gonna have if we do this bill. Oh, just those 285,000. Okay, thank you.
All right, Delegate Lopez, thank you. You're welcome to stay, but if you wish to go. All right, I see Delegate Lefwich. All right, so what we're doing, you went here and then I'll do Prezak. We have 9 bills. We're sort of presenting ideas, and then we're going to let public comment, and then we're going to start the sort of slicing and dicing. And I tried to tell everybody that probably Lopasi's bill will be the primary bill for ideas, just because he had the idea a couple of years ago, right, giving him sort of authorship. Go ahead. You have a specific issue about child support, is that right?
Yes, sir. Mr. Chairman, members of the committee, this bill deals with section 46.2-320.1, the collection of child support arrearages. Currently, as I understand the statute, in order to avoid having your license suspended, you have to reach an agreement with the Department of Social Services to repay your support, and during a minimum period of 10 years. And so what the statute does, it provides the department with the ability to reach agreements that would stretch beyond 10 years. And the first scenario would be that they agree to repay over a period of time, but that would also include a wage withholding, which is not included in the prior part of the statute. And once you've got the employment information, you get the wage withholding, then it just automatically comes out. You don't have to worry about calling the person up every week or worrying about getting it. The second would be in the case of an indigent person, which is a whole different income status, or lack of income status, if you will. And that just basically says the department can negotiate with that person and arrange a repayment schedule in accordance with their ability to pay. So it does provide the department with some discretion to at least get something in. And I'll defer all questions to
I'm sorry, I was doing 2 things at once. You and I spoke on the floor, and someone had told me there's a federal overlay to this. Am I right? And if so, what's the requirements under the federal overlay?
All right. Can you answer that?
Yeah.
Chairman, members of the committee, Craig Bersham, Deputy Commissioner for Child Support. There is a federal overlay that requires, as part of receiving federal funding under the child support program, that we have a state law in effect that will allow for the suspension of driver's license and other licenses.
Okay, so we are currently satisfying that. Does his bill still, do we have to worry about the Fed? I mean, is there any aspect of this that would impact the Feds?
No, it's very broad, the federal language, and lets the state craft what that suspension looks like.
Okay, all right, thank you. Now, Delegate Lethwich, I know we talked a little bit on the floor. Currently, is it suspended or nothing? Because of course, the in-between step is restricted licenses that let you go to work, let you do childcare, a lot of the steps you would want to have under somebody that you're trying to, encourage them to pay, but you would want to take away their job. Can they do that?
I'm not aware of any provision that requires a restricted license.
You can apply for a restricted license once your driver's license is suspended for all kinds of reasons, to go to and from church.
No, right, can you do it under this section? Does this section allow you to get a restricted, to make such application?
Yeah, the current law does, yes.
Okay, so Delegate Lethwich then, what's the issue? In other words, if they get a restricted if they're allowed a restricted license, I understand they might be suspended for something else, and that's what we're going to work on for the rest of the day, but what's the...
So the problem, the issue we have is when you come in, once we've suspended your license, in order to reinstate it, you have to pay $600 or 5% of the arrears, whichever is greater. And what we found is we have a segment of the population that just can't come up with that lump sum payment.
I see.
So
Is that in the code, or is that in some...
that is in the code. And really our enforcement measures aren't supposed to be punitive, they're supposed to encourage people to start paying their child support. So what we want to do is say, hey, if you started working and you have a wage withholding, which we know once we get a wage withholding, we collect the child support, then let's go ahead and let you get your driver's license back, and we can add to that wage withholding a payment towards the arrears. Or if you're indigent, okay, come on in, we got all kinds of programs for non-custodial parents where we can try to help them overcome whatever barriers they have, and also put them in an intensive case monitoring program, which the General Assembly passed several years ago, that would allow them to get their license back and work with us, and we work with overcoming their barriers. So,
okay. All right, any other comments on this? We're going to take public comment on sort of everything all together. This, I think, is independent of the other bills, so even if we kind of combine a lot of the bills' ideas into one big bill, probably the LaPasi bill, this might be a freestanding bill. So if you could sort of stay, if not in the room, but at least close, so when we get to it, you're here.
And capital and
Okay.
mustard and wine.
Okay.
and
All right.
stuff.
Excellent.
But do you have any more idea? Okay.
All right. Is there a Delegate Krizak? I'm sorry, Delegate Albo, did you have something?
I was just going to say, if that's all the delegates we have, I made a list.
No, we've got several more.
Oh, okay, I've been making a list of possible solution types. So we got total repeal.
Right.
We have everyone gets a hearing. We have everyone who wants to
We
get a
haven't even
hearing.
gotten to the two big ones yet. We got LaPasi and
We don't have those yet.
we've not, neither of those. All right, Delegate Krizak, he was here a moment ago. Delegate, so you've heard us say we're trying to just make sure we kind of have all the ideas for the stew, and then we'll, we got Adams, Bell, Ferris, LaPasi, and Habib.
Thank you, Mr. Chairman. So what I'm going to be brief, because obviously you've heard all the arguments on this, but what I'm going to try to tell you is how this HB 2049 will differ from the ones you've already heard. This bill eliminates the suspension of driver's licenses for non-driving related offenses. So we're talking about, so you have a driving related offense. This bill does not apply to you. It removes the suspension of driver's licenses for failure to pay court costs and the fines for non-driving related offenses such as trespassing, shoplifting, those kinds of things. There are 42,892 persons a year, or this year, that are suspended for non-driving related convictions. So that's who we're dealing with. The bill will seek to target driver's license suspension to those people who have committed driving offenses and are in danger on the road. This will provide relief for those suspended for non-driving related offenses. I think that's really the difference. And you've heard all the other stuff. So
what would happen for the most misdemeanor cases? The only penalty is a fine. You don't go to jail. You don't have supervised probation. Typical trespass or shoplifting, you get 10 days in jail, all suspended for 2 years good behavior, and $100 fine to be paid. And you pay within 30 days. If they don't pay, what happens under yours?
Well, the same, you just have the same kind of, like, there's your same mechanism, show cause mechanism, you'd have to, I mean, nothing changes, all we're doing here is we're saying that you can't suspend the driver's license, that's it. There's just no suspension for
So
those
for all of
42.
those tens of thousands that are not paying, there'd be a show cause and you go to jail?
I'm not changing anything else, it's whatever, it's what the code is as it is now.
I'm asking you, if we take away this penalty, what happens to somebody that refuses to pay the fine?
And remember, I'm only talking about those people who refuse to pay the fine that have, that's not a driving related offense, right?
I've
So
got it.
for those folks, it would be you would go the same thing you do normally if they refuse to pay the fine. You just don't have a driver's license to suspend it. You don't have that piece, that's all. Right?
I'm asking you, I mean, do you want us to, there's only about 5 penalties we have.
Right.
We've got
So we're
jail.
taking-
Well, first off, we have don't break the law.
Right.
So pass that one. We've got, you gotta pay a fine. Don't wanna do that. We've got probation, but that ties back to the fine, they don't wanna do that. You're left with either they don't pay and nothing happens, or they go to jail, and I'm asking
Right,
you.
they go to jail. The reason for this is,
And
what
you
I'm
gotta
trying
take
to
them
do.
down, serve them, find them, not on supervised probation, you gotta, the deputies are gonna spend time serving the paperwork, they come back in, we have a new charge that arises.
Right, well,
I mean, if you
I mean,
like
the
jail,
reason for the-
you're welcome, but.
Mr. Chairman.
Yes, sir.
so the reason we're worried about the driver's license suspensions is that you can't pay the fine if you don't have a way to get to work. So I mean, it's kind of counterintuitive, so we're trying to make it so that you keep the you don't suspend that driver's license, you let them use that to get to work to be able to pay the fine. So that's the goal here.
I mean,
And it's not,
okay, I understand what you're saying, I just said that if they didn't pay, it would be the obligation of the court to issue show cause, it would be the obligation of law enforcement to find them again, serve them, bring them back to court. They would then be in front of the judge, with the only penalty he could impose would be jail, right?
right, which would be the same thing for anybody now that doesn't have a driver's license, I mean,
But we don't do it.
yeah, okay.
No, I'm saying,
I
if
see
you
what
have a
you're
$100 shoplifting case and all you don't do is don't pay the fine, I'm not aware of any court in the Commonwealth that does a show cause, brings you back and locks you out.
Right, well then,
Because you are paying a penalty by not being able to drive, and that's what ultimately gets people, why do they ever pay?
Motivate.
well, my concern is that we're becoming the traffic court is becoming a collection agency.
This doesn't affect traffic court, right? This is the non-traffic court.
Right, that's true. This is,
Okay, I'm not trying to embarrass
I
anybody
totally
or anything
understand.
out, I just wanna make sure I understand what you're suggesting
guess-
and proposing.
yeah.
Okay,
So when you craft this bill, I would just urge that part of it, that the non-driving related offenses, those are the folks that should be carved out.
all right, thank you.
Thank you very much.
All right, you are welcome to stay. We
I
heard the
can't, 'cause I've
ideas.
gotta get back to
No, I'm not trying to make it, I'm just saying, okay. Left which has been heard, let's do, Les, do you wanna do yours?
Yes, thank you, Mr. Chairman. My bill, HB 2051, is very, very specific.
Yeah, I'm sorry, go ahead.
It's just very, very specific idea, and that is to eliminate the driver's license suspension in cases of first offender drug possession, marijuana possession, actually. It's very specific for that, and it's, the draft that we have allows a judge to impose a suspended license, should he feel that's an appropriate punishment. But that's basically it.
Delegate Alba.
Is yours keep the mandatory thing in for juveniles?
Yes, it doesn't change the language that relates to the juvenile code. Yes. It just says that for purposes, the portion of the statute that's amended is the last paragraph where it starts with notwithstanding any other provision of the section. All these other code sections that automatically suspend a license go into effect anyway on the first offender. We're adding one line, however, if the court places an individual on probation or terms and conditions for violation of marijuana possession section, such action shall not be treated as a conviction for purposes of those suspension statutes, provided that the court may suspend or revoke. So if there is concern by the court, that needs to happen in this case, it can happen still. But it's not required. It's not required for simple marijuana possession. Okay?
But it would be with the juvenile.
Yes, yes, and that's the next sentence that is unaltered. Okay?
Delegate Adams, thank you. Anything else? Okay. All right, Ferris, I've talked to Matt about this. David Cotter, could you describe Matt Ferris's bill briefly? I've talked to him, I don't anticipate plans to go. There's a way that you could get a note from your boss and that would allow you to get others. Someone describe the bill just while.
Mr. Chairman, I can take a quick stab at that. Basically, Delegate Ferris's bill, if somebody gives to DMV a written offer of employment contingent upon them having the driver's license, that DMV will restore in full their driver's license, but also put in a wage withholding of, I believe it's 10%, or $100, whichever is smaller, or whichever is greater. And that would be, that is the really boiled it down basic. And that's only for fines and cost suspensions, obviously.
Got it. Okay. I will do mine, and then hopefully by the time I'm done, I won't take very long. Lupasi will come. If that's not, if someone from the agency, Mr. Secretary, you are welcome. Let me do mine, and then if you want to present the Habib bill, if you wish, or not, and then we've got the Lupasi bill.